Good morning, everyone. Thank you for joining today's program, Growth and Opportunity in Latin American ADR, the Arbitral Process and Beyond. My name is Hernando Otero, and together with Sherman Humphrey of JAMS, I want to welcome you. And so I'll just start by telling you that we're welcoming you and thanking our co-organizers, which include the Mediation and Arbitration Committees of the ABA's International Law Section, the Miami International Arbitration Society, and of course, JAMS. And last but not least, our supporting organization, Arbitral Women. Today, we are joined by people who have registered from over 28 countries around the world, including representatives of some of the leading ADR institutions in the Latin American region. So we'll have the panels for about 90 minutes. We'll have a Q&A portion at the end, but please submit your questions as they arise so that we have them ready by then. You will also be prompted to take a brief survey at the end should you need CLE credits for California and New York. And CLE materials will be emailed thereafter. So let's get started with our first panel, in which we will hear from Ms. Mercedes Tarrazon. Mercedes is an international arbitrator and mediator, a fellow of the Chartered Institute of Arbitrators, both in arbitration and mediation, and a distinguished fellow of the International Academy of Mediators. She is the founder of Dispute Management in Spain, but she regularly serves in high-profile cases across the Americas. More importantly, she is a thought leader and someone who I always look forward to hearing. She will be interviewed by an experienced arbitrator and mediator in her own right, Ms. Damali Peterman in Washington, D.C. Ms. Peterman is a mediator and arbitrator with JAMS, but really has a wealth of experience that includes her past as a transactional lawyer and an in-house attorney that she brings to bear as founder of Breakthrough ADR. She also has a great podcast titled Breakthrough Barriers, which I encourage you to check out. So Damali, we're in your hands.
Thank you, Hernando. Welcome to everyone who's tuning in today. We are very excited to have Mercedes Tarrazon here, and I would love to dive into this interview because we all want to hear you speak, Mercedes. So please, if you could, describe yourself in 6 words.
Well, let me first thank the organizer for having thought of me and Hernando for his very kind introduction. Well, in 6 words, I would say that I'm a multilingual dispute resolver who assists parties in finding solutions.
Oh, I love that. A multilingual dispute resolver who assists parties in finding solutions. So that leads really nicely. It's a great segue into the work that you do, Mercedes. So tell us, what is it that you do? What do you like about ADR, and specifically the arbitral process?
Well, what I do, I'm a practicing lawyer who sits often with my own law firms, who sits often as a neutral, as an arbitrator, as mediator or conciliator, or as member of dispute boards. I have to say that my first professional stage was in family businesses, which has given me a solid experience in corporate management and governance. And I mention this because I believe it has proven to me to be very, very useful for my work and the way I do it. I mean, clients, even as a lawyer, clients feel very much understood because I'm someone who's been there and for many years. And I always say that first and foremost, I'm a businesswoman. So, and probably also that background has made me has brought me to dispute resolution. Because when you say what I like about ADR, well, in this business, we often talk about the conflict industry, but I like to say that I work in the solutions business. And the ADR, it's when the conflict is there, which is the problem is there, and the problem is inherent to life. I mean, wherever you go, the conflict is there, and there's nothing wrong about it. It's part of it. It's part of life, and it's part of the business or legal relationship, no matter in which situation, I mean, you can have conflict. So assisting parties in solving that, in finding a solution, in being able to move forward. And it's something that I simply, that I love. I mean, it gives full sense to my life. In particular, if we talk about arbitration, I think that one of its special charms for me is that serving as an arbitrator, I mean, sitting as an arbitrator, is a unique opportunity to enjoy the law, because it is the sheer intellectual exercise without the limitation that in a certain way implies approaching a legal matter from the need to defend certain interests, which are those of the client. So you can suffer a lot when you don't have experienced lawyers, counsels, when you see the imbalance, then you can suffer a lot, because you cannot substitute the role of the counsel for one party or the other, because it is not your role. But when you have good, and you very often have good counsel in both sides, it is a pleasure, because you enjoy the law, the intellectual exercise, then you enjoy the logics of seeing submissions and evidence and seeing what is being accredited and what is being accredited, one needs to. So it is, well, as you can see, I talk with a lot of passion about it because I think it's great.
I'm happy you mentioned that passion, because your face actually lit up when you were talking about the process. And you know, I liked how you were talking about normalizing conflict, that conflict is normal. And so it's something that's going to occur. And so that's why you're in what you call the solutions business, which I think will resonate with a lot of people on this call today. I also saw that passion as you started to talk about the various roles that you've had in ADR, from being an attorney, starting off in the family business practice, to being a conciliator, you mentioned, a mediator, and then you started to tap into the arbitral process and what you liked about working with various, you know, representatives, counsel, and then helping them to work towards a solution. I know you do a lot of work in Latin America as well. And so I'm curious to know what's unique about the arbitral process in Latin America.
Well, I wouldn't say there's something unique in the arbitral process in Latin America, because Latin America, which, by the way, when we talk about arbitration, Latin America includes Miami. Of course, you know that. So it means it's large America. So there are all the countries in Latin America have nowadays modern arbitration acts. They have, there is a vast community of very experienced practitioners, very familiar with the most important rules in arbitration. What I would say, so it is not unique, there's nothing specific of the arbitral process, because the arbitral process, in no matter which arbitration in those countries, I mean, mainly the big countries are all the civil law countries, but I mean, the standard and the practice and the process of the arbitration is held in the way, no matter in other parts of the world you would hold an international arbitration. I had the opportunity for many years. I was member of the Inter-American Commercial Arbitration Commission, and there I had the opportunity to meet and to work with several regional arbitration centers in Latin America. And I would also like to mention the quality that we can find nowadays and the hard work that has been done by those institutions to have modern rules, to really follow the best practices. So be it that you have an arbitration administered by one of the big, the ICDR, the ICC, or by institutions in Santiago de Chile, in Bogota, in Lima, in the centers in in Ecuador. I mean, there is huge quality, and that's a message I would like to leave very clear, because there is quality, there is experience, and we are seeing, and it is true also that it's very easy to appoint arbitrators over there, because I mean, you can easily have someone from a different nationality who's also, the legal systems are very similar. The language, of course, either Spanish or Portuguese in Brazil, but I mean, there's many practitioners with speaking those languages. So I would say that there is an increasing number of arbitrations, and it's been increasing for the last decades, an increasing number of arbitrations. I have recently seen, and will be seeing more of that, cases between Latin American parties and Asian parties, because there's a huge market. And so I think that's also an area of interest for practitioners to bear in mind. And it's an arbitration friendly part of the world, with huge experience and with very solid working. The courts, I mean, I can't go on different because so many countries, but there is a huge work done by the arbitration communities in those different countries to make sure that the courts are familiar with arbitration, so that you don't have issues in executing awards and so on and so forth. There would be elements to mention, but I won't enter in all the detail. But I would say, and you can always go for a seat of the arbitration where you think you are more familiar with. I mean, if you are as counsel drafting a dispute resolution clause, but I think there is quality and experience all over the zone.
That's excellent, and I think that we'll hear a little bit more about that quality and experience with the next panel, because we have some arbitral women, if you will, that are going to give a little more color from several countries. And I love that you talked about the fact that there really isn't anything unique about the arbitral process in Latin America. It's a quality process wherever you go. You have a lot of experience. There are model clauses that are being utilized. And now, because it's been something that has been utilized in various dispute resolution systems in various countries, and I like that you included Miami in Latin America, then there isn't a problem in most jurisdictions in carrying out the arbitral awards. And so we're seeing this use, and I would say sort of working together across various platforms with various types of arbitrators within Latin America. And it's something that has been utilized for decades, and it's become even more popular, I would assume, over the last 18 months or so, where we've had disparate reactions throughout the world with respect to resolving conflict given the pandemic. What I would like to sort of turn you towards now is just a question about, because I had an opportunity to talk to you before this broadcasted interview, and it was such an enlightening conversation, because I listened to you talk about different opportunities that you've seen either before, during, or after the arbitral process to incorporate other types of dispute resolution processes in Latin America. And so I'd like to ask you that question now to kind of get your sense of different ways you sort of see the arbitral process being, I don't want to say updated, but just sort of being utilized more creatively.
Well, thank you for that. That's the question nowadays, because we are seeing more and more, and there is an increasing interest even in institutions to see how they combine mechanisms. The first thing I would like to say is that that one thing is how to combine processes. Okay, that's what I'll be talking about. But I believe that arbitration should be done by one person, mediation by someone else. I mean, changing hats has many risks, and I don't think it has any advantages. And I'll touch upon this a bit later. But combining processes, not the same people doing this, no, but combining mechanisms, I mean, certainly arbitration is a mechanism where is a third person or tribunal giving you solution, the legal solution to your case. And so, well, solution, the legal answer to what you have, the parties have submitted. There are opportunities to try to find a solution that is negotiated among the parties. It is not something that is imposed to them, but it is negotiated by the parties. So you can have that assisted or facilitated by a third neutral, which is a mediator. And the opportunities, as you've said, Damali, you can find them along the process. You can do that at the beginning, before starting the arbitration. That, I mean, it is difficult that parties go to that or try a mediation before the arbitration, unless they have a multi-tier clause, which asks parties, the multi-tier clause has been agreed by parties in their contract. I mean, it's not imposed to them, but if they have agreed to try mediation, I say mediation, it could be another facilitated mechanism, but often the most familiar mechanism where parties are assisted by a third neutral who facilitates a negotiation among them is mediation. So if this is done, if there is this multi-tier clause or parties agree to go to give a try to mediation, I would say it certainly helps, but I would say it only works if the case is prepared for mediation. I mean, you really have to analyze the case, know the strength, the weaknesses, try to think of the strength and weaknesses of the other party. Preparation is common, no matter if it's arbitration, mediation, or whatever. I mean, preparation is a need in life, so be prepared. If you are prepared, you have to know how much evidence you have to support your claim, which is, I mean, because in the end, what an arbitral tribunal will do is analyze what the claims and how much evidence supports the claim. Because so you can do that before. Doing that before requires setting a deadline for that period, because you don't want everybody to keep on, no, because we're negotiating, we don't go yet to, no. I mean, there's a period to do that. If really negotiation is being fruitful, you can always have parties agreeing to extend that time limit, so that deadline, so there is no limitation for that, but put a deadline to that, and do that in good faith. I mean, if it's only to make other parties lose their time, honestly, wait until the deadline is over and go to arbitration, because I mean, all these things mean energy in terms of time and fees, and so I mean, if you are not going to do, and then if during the process, during the arbitration, it is easy that the arbitral tribunal can identify moments that they will see the tribunal. As an arbitrator, you see the case. Sometimes there is someone who doesn't want to pay and won't pay, so the only thing you can give to the creditor is to give them an award that can be enforced. But sometimes parties will you see the evidence, you see what is, and you may the tribunal may invite the parties to consider going to mediation, or the council negotiating for it. I mean, on each side can agree to open the window for mediation. And then, of course, you can have an arbitral award rendered, which for many reasons, we won't enter into detail, but either it cannot be executed or I mean, there is nothing to execute there. So sometimes mediation is a way to find a final solution, even if you have an award rendered.
That's great. So essentially finding ways to, if applicable, utilize mediation during the arbitral process, and making sure that the mediator is not the same person as the arbitrator, for a variety of reasons you were alluding to before, that you don't think that's that's not an opportunity to kind of share different hats or wear different hats, if you will. Okay, and I also took some notes here with respect to just thinking about some of the same things that you would need in an arbitral process. So just being aware of the timeline, having someone evaluate the evidence to make sure that it's, you know, relevant, applicable, and the strength of your case is clear. And it also sounded like the timing is key too. So depending on where you are in the arbitral process, there are better times than others to sort of infuse some of the tenets of mediation, or using the mediation process to perhaps resolve some of the, I don't know if I want to call them contingent, or some of the other issues that are going on that perhaps aren't the crux, if you will, of what the parties are in arbitration for. I would like to close by asking you one final question. And this is sort of to give those tuning in some tips to walk away with. So what are 3 tips that you want to share today, Mercedes, for people who want to see arbitration or some combination of ADR processes utilized in their industries where litigation is still the norm?
Well, the first and most important tip is that if you want arbitration or another mechanism to happen, you have to include that in your contract. I mean, unless there is a standard practice in the industry which says, or parties, I don't know, have all signed a pledge or something like that. I mean, what will decide which is the dispute resolution mechanism, it will be the clause in the contract. And this needs to be drafted carefully. So, I mean, consider it when you know that what the deal that is being made by parties, so you can understand which would be the mechanism that would serve. Arbitration combined in the sense that opening the door also for mediation, for instance, is interesting. Certainly, if it's an international contract, go for arbitration. There are no international commercial courts, so I mean, either it's your country or the other country. So go for arbitration. If you would like to have this to leave the door open also for mediation, it is better to include it in the clause, because if not, sometimes people, although there is a lot of culture about mediation nowadays, I would say that it's not enough. So there's still that old approach which says, if we propose mediation, it's a signal of weakness. So it is better to have it in the clause. I know that we are out of time because we don't have one minute, but quickly, I mean, consider be aware that if you go for arbitration and you have a serious institution administering the case, you will be having arbitrators who are specialized in the matter, who are people with experience, and you will have a quality in the award, which is always a guarantee for the mechanism. I'm sorry, but you cannot go in more detail.
No, that was fantastic, Mercedes. Thank you so much. That main takeaway for everyone was just to put it in your contractual provision. So have a provision in your contracts that allows for arbitration, and if possible, considering mediation where applicable too, because it could be a very useful technique, useful to use to help resolve conflict. Thank you very much, Mercedes.
Thank you, Damali.
You're welcome. I'll turn it back over to.
Thank you, Damali. Thank you, Mercedes. Very interesting. I think the main takeaway for me is that the Mercedes is telling us you need to prepare for mediation, for successful mediation to happen. And she mentioned several things which I think are food for thought for many people who despair about whether mediation can be successful or not. Know that a lot of depends on what the parties decide to do with that opportunity. So having said that, let's move on to panel 2. Panel 2 will be an opportunity who will be moderating this panel too. She is an international attorney with Ackerman LLP in New York, and her practice focuses on international disputes involving sovereigns, private companies across the Americas, Europe as well. And she has experience with all the major institutions, ICC, ICSID, UNCITRAL rules as well. And she serves on the board of the Arbitral Women Supporting Organization for this event. And she's the ICC's Young Arbitrators Forum Regional Representative for North America. And last but not least, she's been recognized as one of Latinvec's top 100 female lawyers.
You've been in the field for a long time, not as much, but thank you so much for that kind introduction. And I am really happy to be here. Thank you to the ABA, JAMS, MIAS, Arbitral Women, to allow me the opportunity to be here with these three amazing pillars of ADR in Latin America: Cecilia, Macarena, Angelica. I'm very honored to be here with you. And I will, I know that you know them all, but I will be amiss if I don't highlight some of their accomplishments as well. I'll start with Cecilia O'neill, who has a law degree from the Pontificia Universidad Católica del Perú. She has a master's degree of laws from UPenn, from the University of Pennsylvania, and is a doctoral candidate from the Universidad Católica. She's the Dean of Universidad del Pacífico Law School. Cecilia is an arbitrator on proceedings administered by several arbitration centers in Peru. She's also a member of the International Court of Arbitration of the American Chamber of Commerce in Peru, and a director of the Peruvian chapter of the Spanish Club of Arbitration in Peru. Next, Macarena Letelier Velasco, lawyer and master in public law awarded by the University of Chile. Since the year 2014, she's performed as executive director of the Arbitration and Mediation Center of the Santiago Chambers of Commerce. She's a vice president of the Inter-American Commercial Arbitration Commission, former prosecutor of the Chilean Ministry of Economy, arbitrator of the Public Works Concession System. She's author of various publications, speaker at seminars and courses like this one, and in Chile and also abroad. She was awarded the El Mercurio, which is a Woman Leader Award for Women Entrepreneurs in years 2018 and 2019. Last but not least, we have Angelica Maria Perdomo. She's a senior institutional counsel at the International Arbitration section of the Center for Arbitration and Conciliation of the Bogota Chambers of Commerce, CCB, where she acts as secretary for international arbitral tribunals. Prior to joining CCB, Angelica worked as an associate at the Litigation and Arbitration Department of the firm Garrigues. She's also worked at the Colombian National Agency for the State Legal Defense in the Investment Arbitration Department, and previously served at the Colombian National Contact Point for the OECD guidelines. Angelica has also served as assistant professor of international law at the Universidad del Rosario Law School. Please, I know that we're not in person, but join me to applaud these amazing women who I have the opportunity today to moderate in this panel. And let's start maybe with Macarena. I know, Macarena, you're the executive director, the Chamber of Commerce in Santiago. So let's just go back a little on, pre-pandemic, pandemic, last 18 months. Tell me about ADR in Chile. What innovative ideas at the Santiago Chambers of Commerce, thriving during the pandemic? Let us know a little bit more about you and your practice.
Thank you very much, Rebecca. Hi to Cecilia and Angelica. And thank you a lot to JAM for organizing this event. Well, I think this is, we are having difficult times. Everyone knows that the world is living the same problems or almost the same problems in health and in the impact in economy and in a lot of things and matters. But in commercial things, many contracts couldn't be complete. And there are a lot of conflicts open in, for example, with entrepreneurs, between entrepreneurs. So not always they can go to a big arbitration. So I think mediation in these times have been a very useful tool to resolve conflicts, thinking like the most important to protect the relation between those people, because they are in the same situation, someone. So it's just the thing that they don't answer the phone, for example. So the institution acts like a bridge between them. And in that, we have a pro bono program of 1,000 mediations pro bono with the Ministry of Economy, just to give here the society a different way to get out of this conflict. And you know that most, we have finished like the 50% of the cases, and the half of them has ended with a settlement. So I think here is a good way to help in this time we are living, and ADRs in general have, I think they have now a good place, and they are, I don't know if more use is the word, but it has a lot of good impacts between parties because the dialogue is between them, and the center has a lot of tools to help them with the arbitrators and the mediators. So I think that is now what we are living here, a lot of mediation, a lot of arbitrations, but trying to help people to get good settlements, or just to know they have to take care about the relation, because this is an exceptional times we are living, but we have to get away together in this.
And taking on that, on what you've have experienced, I am actually very curious about what's the overview in Colombia, and how is it been going on in the last 18 years and sorry, in the last 18 months, and how maybe what innovative ideas we can find at the Bogota Chambers of Commerce. Angelica.
Thank you, Rebecca, for your question. So as to the general overview of the current scenario for international mediation in Colombia, the first thing to be said is that mediation in general is not a regulated mechanism specifically under Colombian law when compared to conciliation and international arbitration. There are no specific legal requirements for the mediators or for the proceedings themselves. This difference naturally responds to the degree of intervention of the mediator, and in turn to the complete autonomy and free will of the parties to propose the settlement formula and reach the final agreement. Of course, the effects of the final agreement are regulated under Colombian law as a contract, and the most similar figure would be a settlement agreement. Now, this lack of regulation poses an enormous advantage for mediation. That would be flexibility in the procedure to ultimately seek a solution. Yet this benefit, or this benefit apparently obvious for us, doesn't seem to be so obvious, or at least appealing for users who still seem to prefer direct approaches, such as negotiation, or even resorting directly to more contentious mechanisms such as international arbitration. Now, this preference for other methods may answer to a misconception that any intervention of a third party must have some sort of legal validation or a sort of legal background of its own, a law, decree, a code. and the lack of such gives a false sense of insecurity on the outcome. And it is false because ultimately I don't think there is a more solid legal ground than the free will of the parties, right? On the other hand, there might be a reasonable disadvantage for mediation when it comes to international disputes, and that is the enforcement of the final agreement in different jurisdictions. However, I should note that in Colombia, the Colombian government in 2019 signed the Singapore Convention on Mediation. Ratification is pending, but at least, there is this interim obligation for the government to respect and observe the object and purpose of this treaty. So I think that Colombia continues to be on a healthy path towards strengthening international ADR mechanisms, particularly mediation. However, there is still an enormous amount of work to be done to give people a better understanding of the uses of international mediation as a better and more efficient alternative than resorting to direct approaches such as negotiation. Now, this is the case when compared to mediation, but when you compare it to international arbitration, the scenario changes a little bit. In our institutional experience, for the solution of international disputes, mediation, rather than being the first choice, is a very specific alternative for very specific cases, and the general rule is still international arbitration. Our numbers from the past few years show us that from 2018 onwards, there was a surge in the number of international mediations, or rather conciliations administered by the center. Before 2018, we had cases, but the numbers were quite low, and there was an unfortunate tendency that the summoned party didn't even show up. Now, from 2018 onwards, both parties usually attend. And I think this shows that this mechanism is being taken more seriously as a realistic alternative to solve an international dispute. However, in barely half the cases, a little bit less, parties are actually able to reach an agreement. Those cases that end up in agreements, that end up successfully, tend to be ordinary sales disputes, whereas disputes connected to regulated sectors, to more complex disputes in the oil and gas industries, rarely end up in an agreement. So finally, when compared to international arbitration, we see that mediation is growing, but still the average number of cases we are receiving each year for international arbitration, then the numbers are the double when compared to mediation. So the bottom line here for us is that, as a general rule, mediation should definitely be preferred over direct approaches such as negotiation, given all the added value that a mediator can provide. But this is not necessarily the case when compared to international arbitration. I think that it cannot be a replacement, given that the effectiveness of mediation heavily relies on underlying aspects of the dispute, such as the industry, the type of contract, the type of breach claimed. However, the CCV definitely has its doors open for the development of this pre-contentious approach that could definitely work as a good complement for international arbitration to foster the growth of this mechanism in Colombia.
Thank you, Angelica. That's actually very interesting. I have definitely heard that mediation kind of took a peak at the height of the pandemic. So, but I'll put a pin on that, and something that Macarena said before, and I would like to go to Cecilia to let us know how is the environment in Peru, and in your practice. You sit as an arbitrator, so we'd like to know more about your experience, what you've experienced with parties, what would be potentially the mechanism that the parties like the most, and I don't know, maybe some outcomes or lessons learned.
Okay, thank you. Good morning to all. Thank you. I would like to start to thank JAMS, the American Bar Association, Arbitral Women, the Miami International Arbitration Society, for letting me share with you some thoughts about the ADR methods. As you just said, I sit as an arbitrator in Basically, domestic disputes in Peru, but in Peru, the arbitration is quite significant. Actually, some years ago, our country learned that no economic growth is possible if we don't make sure that two important pillars are strong and always protected, which are contracts and property rights. And the role of the state on this matter is making sure that both the judiciary and the arbitration system protect contracts and property rights. That's the first idea I would like to share with you. I cannot share with you in this moment all the judiciary problems we have in our country, which are huge and of course hard to be solved. But maybe I could refer to the main reasons why the arbitration system in Peru is quite successful. No, I have to focus on arbitration because instead of mediation, because I have more experience as an arbitrator. In Peru, the arbitration system is safe because it's assured by basically, I would say, three ways. We have a modern arbitration law. The decisions of the judiciary are friendly with the arbitration as well, and the arbitration practice is quite sophisticated here. It means that as we say, all roads lead to Rome. In this case, all roads lead to arbitration. In Peru, we have actually a single system, not a dual system, which is an advantage, because this is a good way to make possible that international standards filter to the domestic practice. Actually, it's not unusual to have foreign arbitrators solving domestic, not only international controversies in Peru. No? We also have a regulation, an innovative regulation in our law of the non-signatories parties system, which allows all persons to give consent to arbitration to be included in the procedure. And this is a question resolved by a standard of good faith and certain criteria that are regulated in our act. And also the judiciary, as I was saying, respect the arbitration process. Actually, for example, I will give you just an example. If a person goes to the judiciary to request for an interim measure, this can be granted, but as soon as the arbitration procedure starts, the judge has to send all the procedure papers to the arbitration, to the arbitrator. There are more specific topics, of course, but I think we can talk about it later. The other hand, in regards to the mediation process, well, now in Peru, we are not quite advanced in this topic. We have a conciliation law, which is a different mechanism from mediation, but share, of course, some characteristics. No, this legislation about conciliation, it's quite special because instead of making the parties getting closer, the conciliation law or the conciliation process is perceived by the parties as a, I don't know, as a maybe a too automatic process. The parties don't take it seriously. They think that they have to go to make a, check and then start moving into the litigation process. But however, in AmCham, the American Chamber Center, We of course organize and administer arbitration and arbitration related services, including mediation in theory, but we are trying, to promote the use of the mediation. Actually, we are currently working with an very active commission, advisory commission, for the elaboration of our mediation regulation. That's what I can share with you at this stage of this meeting, I think.
And on that point, and I think Angelica talked about the Singapore Convention. I would like to see what probably Macarena, if you have any comments on the Singapore Convention.
Yeah, Chile signed the Singapore Convention too. It has not passed through the Congress. That is the second thing that we must do. But I think that it's a good sign, because we don't have a public politic about mediation in civil matters. We have that in familiar things, on labor, for example, but we always put, for example, Colombia here in Chile with the law in mediation or conciliation, as you said. But we need, because that helps the culture to change. Many attorneys or inside lawyers in the big companies, I don't think they are a good or bad person because they know or prefer mediation. It's a different way to resolve things. In international arbitration, we don't have a lot of mediation cases, but this convention of Singapore will help us, and will help to have a different look about the mediation. And maybe there will be a day that all of us will think that this is the best way, because it's flexible, because the parties with the expert, the mediator, gets to a settlement that they look themselves. And that is very, very important. When you are in an arbitration, that is a very good way to resolve things, because it's efficiency. The people know that the arbitrator know about the thing he's called to resolve. There is a lot of space to dialogue too. But at the final, if you don't have an agreement, someone is going to see the law, the contract, and it's going to tell you who has the reason or not. And that's a perfect way. But I think that in these times, and in things that we are living as Chilean people here too, we need to exercise dialogues tools, and mediation, it's a good way. So we are hoping that this project of law will enter soon to the Congress, and that we pass this convention of Singapore to the parliament too, because I think that's the way, or that's another good way.
Thank you, Macarena. So we have two countries. Colombia has signed the convention. In Chile, they are in Congress. And Cecilia, we have a conciliation law, but what about the Singapore Convention?
Peru, I must say that Peru has not signed the convention. Yes, we haven't signed it yet, despite this is a good instrument for the facilitation of international trade. But no, we haven't. Perhaps establishing some kind of what Mercedes had said before. Maybe these tiered clauses might serve as a link, between mediation and arbitration. Maybe I've seen in some procedures, arbitral procedures, especially when the state, el Estado peruano, is involved in concession contracts, for instance. Parties are supposed to go to negotiation before entering the arbitration, but no, we haven't signed the convention yet. No.
and talking about these staggered clauses, you know, I know Mercedes spoke about them, and I'm just gonna, you know, kind of like probably put my devil's advocate hat for a second. And there was some conversation about, you know, sometimes the mediation not being completely effective because of the parties, or maybe because one of the parties uses it as a delaying tactic. There are some institutions I know in the rules, they have the possibility of, you know, you start your arbitration, but at the same time you can in parallel have a mediation precisely to avoid that situation. And so would you know, what are your thoughts about staggered clauses in that sense? And Angelica, I don't know if you have, I would like to start with you.
Sure. In our experience, staggered clauses work depending on how they are written. It's actually, in our case, it's very rare that we have a mediation in parallel or a conciliation in parallel to an arbitration. Actually, the case is always that they have exhausted this preliminary phase and then they just get to us with the whole controversy in course. But we have seen cases in which the beginning of the arbitration has been severely delayed due to poorly written clause. So they don't establish clear terms, or the terms are established, but then the interpretation on which is the time zone applicable. Some things which you would think they are very accessory to the clause, but we have had these cases in which there has been discussions about what is the time frame we should take, and then these sort of discussions only end up affecting the parties because when they get to the arbitration finally, they are already exhausted of discussing unnecessarily. So in our opinion, these clauses can be very helpful, and they work as long as they are actually, you know, properly constructed to serve a purpose of helping the parties' interest. Otherwise, it will be an ordeal to get over that part.
Macarena, what you've seen in chambers?
Yeah, I think this kind of clauses are more used these last years. And I think that the lawyers too goes, for example, in the first part of this clause to the mediations, because before they just ask for the arbitrator. They say, no, baby, we don't want, we just negotiate and we didn't get a settlement. So, and now that is changing. And I think that is a good news for us. But I think that is a long way to run in this matter, but there are more use. The parties feels today that this is a good opportunity for them. And maybe they are not going to get to an agreement and they pass through the arbitration. But you know that in one case, for example, an arbitrator that the parties didn't talk about one issue in the mediation asked them to go back. So there are the little things where you can see today that the feeling of the parties is changing when they think about mediation. And they always dialogue too and get agreements, and during the arbitration, that is a truth here. But they are very used, this kind of clause, and I think that they are used in a different way that in the past years. So there has been a job between the centers, between the lawyers, between the mediators and the arbitrators, but with the universities too. Because now we are teaching the future lawyers about mediation and about the good faith to when you are with this kind of clause. You just don't say, no, I don't going to go to this meeting with the mediator because I just don't want to talk to the other person. So I think there is a good space and a good challenge for us in the academy to teach about the good faith in this kind of clause too.
And Cecilia, have you had any cases in where, you know, it came to arbitration after a mediation, or the parties were still working on the mediation, or someone used it as a delaying tactic? What has happened in your experience?
It happens exactly what you've just said. This is used as a delay tactic, you know, and also remember that in Peru, this is something important to have in mind. In Peru, one of the ways that lead us to Rome, to arbitration, is that the public procurement needs to use the arbitration clause. In other words, the procurement arbitration is mandatory. Even if the bidding conditions of the contract omit the arbitration clause, a model clause will be applied. This is why perhaps the arbitration system has been developed in Peru, because we have a lot of arbitration processes. But bear in mind that in-house lawyers, I mean, the administrative entities, lawyers, are afraid of being, you know, charged because of reaching an agreement instead of fighting. You know, we live in a culture of conflict, as Mercedes said. The good thing of being a mediator or arbitrator is that we work with the solution, no? But we do live in a conflict system. So in my experience, unfortunately, these type of staggered clauses are not that useful, at least in my experience. I hope it was it's different, but it's not.
And now that leads me to potentially my next question, in which we've been talking a lot about mediation and whether, you know, these staggered clauses work or not. But I remember Mercedes in the previous panel said that, you know, arbitrations, they have a charm because you have an opportunity to enjoy the law. And she lit up when she was talking about this. And so I'll start with, I'll pick on Macarena and ask her, why arbitration over mediation, or vice versa?
I don't think that is one or another. I think you have to know about the relation between the parties that are in the conflict, because maybe you have a lot of another contracts. Maybe you are family, maybe you are friends, or maybe you haven't had a good experience before in a mediation. So I think that you have to look deeply to the conflict and the relation between the parties. But said that, I think that it's always good to try in a process that is flexible, that is shorter in time, and that cares a lot about the relation between the parties. But in arbitration, the times are good, that when there are like difficult conflicts with law or innominate contracts, you need an arbitrator that applies the law sometimes, and that it's a good history for the parties too, because maybe they have more contracts in that way and they need to clear about one point of the law. So I think that depends the kind of relation with the parties and the kind of conflict too.
Thank you, Macarena. Angelica, do you have any different views or perhaps similar or different experience?
Actually, it's very, very similar. As I was mentioning previously, what we have identified from our experience is that one is not the substitute for another. Perhaps international arbitration is still the preferred mechanism given the judicial culture here in Colombia. People feel safer when resorting to international arbitration. However, this has proven to be, mediation and conciliation, an excellent mechanism for certain type of industry. So as I mentioned previously in my presentation, maybe not for oil and gas controversies, but maybe for industries related to clothing, food, hotel services has proven to be great. It's usually for long-term distribution relationships in which conciliation and mediation can help not only save costs during the dispute resolution, but also to prolong the existence of the contractual and commercial relationship between the parties, rather than just killing it with an arbitration, which is what usually happens.
Thank you, Angelica. And, Cecilia, I think I can maybe draw your conclusion, which will be maybe arbitration over mediation. But if you had to pick mediation, what will be probably some of the highlights or the key points that you would probably, take in order to potentially have a successful mediation?
I would say that what I like about mediation, despite I didn't have experience as a mediator, is that we can foster the value of empathy, which means to put ourselves in the place of the other. I think not just solving the problem, but also thinking how to do it in a friendly way for both parties, I would say. Said that, I would also say that I suppose that being a mediator as well, but being an arbitrator is fantastic because of the intellectual process. I work in the academic world as well. I enjoy so much being a teacher, I love my students and thinking with them together. So the intellectual process, the process of trying to get the real meaning of the law, in this specific case, how to apply the good faith standard, such a vague standard in a concrete case. That is something that I enjoy a lot, I think. Yeah.
So Mercedes was absolutely right about arbitration, having that charm and the opportunity to enjoy the law. I can see that you also lit up when, and many here on my screen when, you talked about arbitration. And now, I mean,
and
talking
students.
and the students, absolutely. And talking about this different mechanism, which, it's not only arbitration or mediation, there was also a mention of negotiation, conciliation, which tend to be, having similar points or elements. There's also this question about access to justice. And I will just open the floor for all of you to maybe enlighten us about how has public policy in your jurisdiction contribute to the development of ADR and that access to justice. And I ask that question essentially because, sometimes when we think about access to justice, we think about the judge and your day in court. You don't think, for the most part, you don't think about your day in court, your access to justice when you are in front of a tribunal or in front of a mediator or a conciliator. So what has been done in your respective jurisdictions to promote this and give people their date in court? And I'll open the floor. Whomever wants to speak first, please be my guest. Don't trip.
Maybe I can start by saying that I think that the role lawyers have in society is make the person's life easier, So I think there are constant challenges to think about how to do it. In Peru, we are very far away of getting the ideal access to justice paradigm, but I think that the work we've done with promoting the arbitration process is quite important, because for us, especially with the problems we have with judicial courts, is quite an advantage to go to arbitration. It's important to say that part of this access to judgment is that the judiciary is very keen to reject defenses that try to avoid the arbitral agreement. You know, actually the judges have the obligation to forward the parties to arbitration when one invokes the existence of an arbitration agreement. There's no discussion unless the arbitration agreement is evidently null. But in general, I would say that no, and Peruvian courts take this duty very seriously. And on the other side, we used to have a lot of problems with arbitration to the constitutional courts. I don't know if you all are familiar with Acción de Amparo, but I would say that I have to say that the Peruvian constitution recognizes the jurisdictional nature of arbitration. We've had different cases, judiciary cases, that were not quite clear about if we could start an amparo, acción de amparo, I mean, before a constitutional judge to avoid arbitration. But we have a very important leading case now, the leading case Maria Julia, that has said that no injunction against an arbitration award is permitted unless some very specific scenarios occur. I don't want to get more deeply about it, but that's an important thing. And the centers have an important role as well. No, in AmCham, we've just made some changes to our bylaws to promote efficiency, in procedures. For example, we have included the emergency procedure. We have included, as well as other centers as well, the waiver of the right to object. When parties say nothing about a problem during the procedure, you can't go back and say, okay, oh, sorry, I forgot to say that there's a problem. You just need to go forward. Or we've just incorporated the procedure for scrutinizing the award and so on. So it's a very complex issue. Sorry that I keep talking, but there are so many issues to talk about.
Macarena?
Thank you.
Yeah, well, I think, Rebecca, that the best way to promote ADRs here in Chile has been the respect of the judiciary for these mechanisms. Less than 2% of the awards in national and domestic arbitration has been revoked by the court, and in international cases, no one. That doesn't, I don't want to tell or that you think that they don't make the work, but they respect a lot the autonomy of the parties that has choose these ways to resolve. But if the arbitrator makes a bad settlement award, they are going to ask to change it again or make a new one. But that thing, with the interconnection that we have in technology between the center and the judiciary, has been a very good news, because now we are interconnected. So when you have a case in the center and you make, for example, an appeal or any recourse, you can go through the same platform between the two institutions. This is the first agreement with a private institution like the Chamber of Commerce, that is not profit, but is known like a private sector. And that is like the photograph that I always show between the relationship with the judiciary. We collaborate with them, we make a different access to justice. It's not easy to access to justice, I think, in any country, but it's part of take care of the democracy and the dignity of the people. We are not living easy times, so welcome to any way to resolve conflicts.
Thank you, Macarena. And Angelica?
Yeah, just some final remarks. I think my co-panelists have said almost everything. In Colombia, the case is very similar. The judiciary is very respectful of arbitration, particularly international arbitration. And I think that respect fosters and consolidates this mechanism. Now, I would just like to add something, and it is that with the pandemic, I think one good thing that was left is that the government was forced to implement several policies to enforce virtual proceedings, which for us in arbitration mediation is quite normal, but before the pandemics, it was very, very rare to see that in judicial proceedings, in ordinary proceedings. Although it was legally regulated, it was rarely implemented. So I think this definitely promotes access to justice, particularly in regions in Colombia. Colombia is a very big country, and there are some parts which unfortunately are isolated or are difficult to reach. And now with technology, you can unite these parts of the country and grant them access to justice so they can attend a hearing virtually. And this applies also for, of course, for arbitration and other sort of mechanisms. So yeah, just to add a little bit to what my co-panelists just said.
And now that you touch upon that subject of virtual hearings, I want to ask a question about that. But before, I mean, I have heard from in Colombia, in Peru, in Chile, there is seems to be a lot of respect for international arbitration. Do you have any comments on why that may be?
I guess in the Colombian, if you allow me to start in the Colombian case, there are many reasons, but I would just say the main one is that the arbitration law is very well constructed, and I think local judges understand that and respect that. Also, they are properly, educated in to understand that this is a completely different regime. Because in Colombia we have a dual system, so that was a challenge when that is a challenge definitely, but I think judges understand that notion, and also because international arbitrators and also national arbitrators tend to be well-known professionals in the legal area, so judges sort of look up to them, and they know that they have, if they made a decision in a certain way, it probably is with good judgment. So that's probably the reason behind it, a good legal structure and also excellent professionals in the practice.
And Macarena, you mentioned that less than 2% of awards, domestic awards, have been potentially overturned or whatnot, but almost none in international arbitration. So is that the same case of what's happening in Colombia? How is the system in Chile?
I think, first of all, that the reason is the trust with institution, because when they see a file that came from the center and they know the work, and that is a responsibility for us, not just a good news, it's a big responsibility. The judges know that there has been transparency, our team between the arbitrators and the parties, all the technology, and a lot of another things. So they look that case with another feeling that may be an ad hoc arbitration. But that makes us to work a lot to don't lose that trust. And in international matters or arbitrations, they respect I love the law, the international law. And as I told you before, this autonomy of the parties, the liberty of choosing this way to resolve the conflicts, and like the minimum intervention of judiciary, just if a law is broken or there is a huge problem, they will go on and maybe they are look over the case and ask for another award. But I think that trust is the word, and trust take us to work a lot with responsibility, just not to lose this trust in the center and the procedures that are here.
Right. And Cecilia, you also mentioned that, for example, if you had interim measures and or injunctive relief, if the panel of arbitrators was already in place, chances are that, the judiciary will respect that and send it to the arbitrator. And I wasn't sure if that was in domestic or also in international, or how does that work precisely in Peru?
No, in both kind of arbitration. Sorry, arbitrator. I was about to say arbitration processes. Judges have to do it because the law is quite clear about it. And also we as many South American, Latin American countries, we are quite formalistic, and so for us it's quite helpful that our constitution says that arbitration is a kind of jurisdiction. Right. So it's very important for judges to remind that. I'm not saying that the job we are is exactly same, no, or that we are kind of judges, but in certain way we try to apply apply justice, so it's if I would have to pick a reason for the respect of in general, not always, of course, but in general, the respect of the arbitration processes, I would say it's the constitution because of our formalistic culture, I think.
And that's interesting because I was formed in a civil law jurisdiction, but I did some of my studies most of my studies in the US. And in the US, although it's a jurisdiction very respectful of arbitration, sometimes if the case, for any given reason gets to the judge, there are some thresholds that you need to probably fulfill or prove to the judge before he sends us, blindly to arbitration. There are certain, I won't get into too much detail, but certain circumstances in which, the judge will take ownership. It can be because, the contract was obviously procured by some sort of, bad faith or who knows. And then in consequence, the arbitration clause, it's not valid. But
it's interesting. Sorry that I interrupt you, but I think it's quite interesting what you've just said. In our cases, exactly the opposite. If you have an arbitration clause which doesn't seem to be evidently no, you go to arbitration. Of course, we have certain, as you've just said, thresholds, but not to go to arbitration, but to go to, to the judiciary, for example, if the award violates binding precedents of the Constitutional Court, where the arbitrators do not apply a rule or a law which has been declared constitutional, when a third party can be affected, things like that. But it's the other way,
It's the principle of competence in the American way or the common law way.
Okay. Understand.
And well, I also want to leave some time for questions. We have many questions from the audience, but I would like to touch upon a subject that Angelica brought up in her last intervention, and it was about virtual hearings. And I know we've been hearing a lot about virtual hearings, and And it was like this wow thing in the beginning. Now people are having Zoom fatigue or WebEx fatigue, or like my microphone. It doesn't like to go from one application to the other. So I need to disconnect it every time I go from Teams to Zoom to WebEx to Jeans and to everything else that we have out there. But, it's interesting to see how the landscape has been changing, and then how much flexibility has been built around a system that is already flexible. And I will start with you, Angelica, because you brought it up. And, I want to know, and I think you mentioned some of the, the shortcomings and the advantages of virtual hearings, access to justice. Do you believe that we will have them here to stay as a hybrid, mode, or if people are so hungry to be, in the same room with people that, that will forget about all of that? And what have you been seeing?
Yeah. In our case here at the CCB, return to on-site hearings or on-site arbitrations seems quite slow, and frankly, it seems unlikely to happen. That we fully go back to on-site proceedings, I don't think it's going to happen, considering that even before COVID, we were already administering proceedings fully on virtual mode. Our rules allow for that. So it was happening before, and I believe it's here to stay. And as of today, our users still prefer online hearings, generally for both safety and economics. Saves time, money, personal resources, everything. Exceptionally, for deeply complex cases, we have seen situations in which the parties prefer to conduct the hearings personally, and even in such proceedings, tribunals and the parties still think twice before going for on-site hearings, considering that today migration policies are permanently fluctuating, and crossing borders can be an ordeal depending where you're going to or coming from. Now, there are definitely some shortcomings to virtual hearings, as you just mentioned, in particular in evidentiary hearings. Some are obvious, such as the impact that virtuality has in the tribunal's perception of evidence, technical difficulties in the middle of hearings that might force unwanted suspensions, the impossibility to fully control the environment from which a witness or an expert is delivering their statements. And there are sure plenty more that we have not discovered yet, and we have not learned to handle yet. I think in the course we'll just learn how to do it. Take, for example, the regulation of technical aspects of virtual hearings. We have had cases in which tribunals issue these very complex procedural orders trying to regulate every detail of the technological aspect, the bandwidth, and then the connection to the computer. And I think that's great sometimes, but also it can create more difficulties in the future. Then how do you interpret this or that? And then you have the other extreme position, and is the lack of regulation, because tribunals don't deem it necessary. And then you have a technological difficulty that might have a procedural impact, and you don't know what to do then. So I think it's a challenge for institutions and for arbitrators to learn how to regulate this properly. But we believe that it's definitely here to stay. Probably hybrid, depending on the case. You'll have necessarily virtual hearings or necessarily on-site hearings. But yeah, even in spite of the Zoom fatigue, I think it's here to stay.
Macarena, Cecilia, any last thoughts on that?
No, well, I think the same as Angelica. This system is going to stay. You know that in the last year and a half, we have had more than 2,000 hearings by Zoom or Teams, etc. But now we are returning. We are having a lot of hearings in the center, but because of that, some arbitrations are stopped during the, for example, the witness time. And now we have like a lot of cases that need hearings. So we are then making in both ways. But I think that the parties liked the think about making distance hearings. But in all cases, maybe the first meeting with the arbitrator will be always in the center. That is very important, face to face. And maybe another can be made by Zoom or another platform. But technology is here, and technology has to be friendly with justice and just make there a good team to give a better life for people that are in any conflict.
Thank you, Macarena. I'm just being told that we're probably going to take a little bit over, so we can address some of the questions of you know, of our audience. And I don't know if Mercedes still over, so we can address some of the questions of you know, of our audience. And I don't know if Mercedes still on the line. Let's see if we can probably address some of the questions. Let's see, we have one here. Maybe Mercedes, you can you know, respond to this one. It says, for a new lawyer in the field, what would you say is important to do or know to become a valuable asset?
Asset in dispute resolution.
Absolutely.
Well, there's a lot of information. So be trained, be before it. There are all these conferences on arbitration and dispute resolution. It was very expensive to be everywhere, and besides, it left you no time free to work. Now, I mean, there's a lot. I mean, there's a lot of information. So be familiar with what you're talking about. I think that it is an increasing market. It must be said there are lots of practitioners already in that market, but I think there are more and more cases coming. In the panel, Cecilia, Angelica, and Angelica and Macarena and you also, Rebecca, were referring to how much these cases are increasing. So I mean, it is not easy to enter the market, let's be clear, but I don't know the person who's writing whether is already in a law firm, whether Diana is in a law firm where she has the opportunity to see cases or not. I don't know whether she's a sole practitioner or not, but certainly, I mean, if you're interested in that, first of all, get trained, get the knowledge and the experience, and from there, get in contact with the centers that administer cases, and read, write, and of course, to write, you have to read a lot first and get trained. But I mean, it's a long-term career. I mean, it's not something that you get there and get the cases. That's, let's be clear. I don't want to let anybody on the wrong way, but I mean, it's certainly a fascinating case, and the older you get, the better for this market. I entered here very young, and I'm happy to, every year I'm saying I'm more prepared, because the market requires experience and they demand, you know, gray hair or at least some wrinkles. But go for it.
And we have also I think a question from Atlanta, from Philip Engel. And he asked that whether, you know, given the developments in the law across Latin America, is there an increased use of core annex mediation or arbitration? Whomever wants to take that one.
Well, may I say that there may be court annex mediation, but not court annex arbitration, because if you're in arbitration, you are not in court.
Right. And I think we have another question from him. And I think we talked about this a little bit, you know, seeing the increasing acceptance of international ADR, you know, if you're seeing an increased acceptance of ADR by small and medium-sized enterprises? What have you seen in, in your practice or in chambers?
If you allow me, I would like to, oh, sorry.
No,
somebody was talking.
go, Angelica, please.
No, just a brief comment. Yes, it's a great question. We've seen an increase of small and medium enterprises using this type of mechanisms. It will surprise you how many of them we have. And they have all sort of disputes. I mean, the fact that they are small or medium enterprises doesn't necessarily mean that the dispute is small or that the controversy is small. We have everything. And I believe that part of that increase in this type of parties is due to the fact that we are, I believe, growing as our judicial and arbitration culture is growing and is being nurtured permanently. So I guess these companies hire professionals that understand that arbitration is a good path, and particularly international arbitration. So yes, we're seeing that, and we expect to see a lot more in the future, hopefully. And also, I may say, because in our case, particularly at the CCB, our fees are very affordable. So I think that also allows for this type of companies to resort to this type of ADR.
Macarena, I don't know.
Yeah,
go ahead.
Thank you, Rebecca. Just to add that in our case, we have had a big increase in cases from small and medium companies. Since like 3-4 years ago, we created a new institution with young arbitrators, almost between 35 and 40 years. They are not so young. I always say they are the best. And the average in knowing from one case are 6 months, and there are different rates. Is a lot of effort too from them. I have to say that they are always having meetings, asking another arbitrators with more experience some things, but they have had never a recourse against an award of a young arbitrators in these cases, and it has been a wonderful, wonderful experience. And then when they just have 40 years and they have looked for more than 5 cases with any difficulty, they pass through the ordinary list of arbitrators, but they have just made this program, and that allows to have a lot of more small cases that are not easier cases. I always say that, or less important cases. But the experience has been a very successful for all the parts.
I have here a question for all the panelists, and I think we touched upon that subject a little before when we were talking about competence, and how whether the case goes to the arbitrator or to the judiciary. And it's from Rose, and she asks, how do you handle parallel proceedings in your jurisdiction? Does the constitution of your countries grants the arbitrator the right to continue the arbitration where one of the parties try to go to court while there is an arbitration pending? And what if it is an issue that deals with corruption, fraud in the underlying arbitration? Does the tribunal stop its functions to allow the court to resolve the matter? I think we touch up on a little bit about that. And this is a question for all the panelists. I don't know who would like to start. Maybe Cecilia. She was very passionate about that subject.
No, yes, definitely. Our court respect arbitration in general, because we have both kind of big topics in regards to the interim measures, which means that arbitrators can even execute their own interim measures unless the police, is involved or things like that. But on one side, and the other side, we have this constitutional leading case, which is quite clear in regards to it. This is not the only case. We have another ones, but this case, Maria Julia, is one of the most important in regards to it. And the other question, I find it quite difficult to answer. I think the debate is open. I think I heard two kind of opinions in regards to it. There are certain arbitrators that say, okay, I would say, okay, that's it. I have nothing to do with it, and I have to, to forward the papers to the prosecutor or things like that. And there's another group of arbitrators that say, okay, the prosecutor is dealing with the criminal process, that's okay, but I should keep working on the civil case. I mean, I'm being asked if there's a controversy, that needs to be solved in juridical terms. There's a contract which is not null, and I need to solve the problem. In parallel, the prosecutor is working on the criminal side of this matter. This topic leads us to another topic, which I find even more complicated, which is a case where a corruption acts have been involved, brings us null contract. This is an interesting question to ask ourselves, and depends. I would say depends. And I don't want to go deeply into the causes of annulment of contracts, but I think those topics are related. I mean, the corruption discussion and the annulment of the contract as well. I don't know if I've asked, sorry, the question, but what I can say honestly is that the answer is quite complicated, I think. But thanks for the question, which is very interesting.
Thank you, Cecilia. And I have a question here that I think I can answer myself, and it's in your experience, particularly for arbitrations held in Miami, how frequently are arbitrations conducted in English versus Spanish? In my experience, it will depend on the arbitration clause. It typically calls for sometimes for, an arbitration held absolutely in Spanish. So you will have an arbitration seated in Miami, and it will be in Spanish. I recently had one. It could be that it's bilingual. So it typically, depends on who the parties are, what the arbitration clause says. If the arbitration clause says nothing, then the parties need to agree. And typically they all agree to bilingual, which, increases the cost of the arbitration. But, it's a party-oriented, party autonomy type of procedure. So, in the end, if there is nothing set in the arbitration clause, most likely the parties will have to agree what language they will use. And to just, just with that one, I'm so sorry that we ran out of time. This has been absolutely incredible. And I would like, to thank all of our panelists, Mercedes, Macarena, Angelica, Cecilia, for your time. And I encourage our attendees to, reach out to us if we didn't get to your question. This is one of the reasons why we also do these kind of, webinars, is just so you can reach out to us later on, not just to, see all of us talking on your screen, but to make connections, since we cannot, do it in person. So I would like to thank you all. Again, I'm very proud to have an all-female panel to moderate, and I will, probably just pass it on to Hernando or Sherman to say probably a final remarks. If they're there.
We are, Rebecca. Well, thank you. I have nothing more to say. I'm very happy with everything we've heard. I imagine so are the attendees. And with that, we'll see you next time. And all the best for you, for the panelists, and all the attendees. All the best.